everyone, and welcome back to the Marlborough Law podcast. Today, it's contested probate. Now, Dan, as you'll know, contested probate really breaks down into three areas. We've got areas regarding wills and how you can challenge the will, dependency, so something which is kind of outside the will in a sense. So you talk about people who were left out and not given enough, and the final one, which is proprietary Estoppel, which is hard to say. So do you want to kick off on one of those?
Well, yeah, I suppose. So it's interesting now because the modern world is changing. We're seeing this, and we're seeing laws changing, etc. We normally fall under the Inheritance Act, 1975.
Yeah.
And that's well known, and you make a claim under that act.
That's a dependency.
Isn't it? Dependency claim. And that's exactly what I was just about to get onto, was the fact that it's interesting now because of blended families. So you got daughters, stepdaughters, and a lot of people don't realise this. Do you have a claim under if a will has been made? So traditionally, people will make a will, and those wishes of the person are upheld.
Yeah.
And you contest it. Well, arguably, yes. Anyone can contest any will, but do they have the rights, or do they strike the right balance to make a claim to the courts, should they need to? And it's different. The timescales are very strict for this.
Yeah, 6 months.
6 months, yes. So you would normally. So what would normally happen is you apply for probate under the normal process, as we know, following the inheritance tax naturally. And that probate is quite interesting because then you would provide the probate office with the live will.
Yeah.
Which is interesting, which I'll get on to the next point, because we talk about staples amazingly.
This sounds ridiculous, but this plays a large role in our lives.
Yes. Yeah, strange enough. Because we had, not that long ago, was it?
Yeah, well, I'll let you finish, then let's talk about staples and the law.
Let's talk about hardware. And this is quite interesting, really, because a lot of people don't realise that it's just words on paper and this is the wishes and feelings, but there's certain criteria. So you can contest a will. There's certain ideas that you can contest a will. One of those, and the main thing, actually, is the mental capacity of a person, strange enough.
Very true, yeah.
And that actually leads at the top, I understand, of most claims.
Yeah, it's really quite logical to think about it. People of a certain age tend to make wills. Are those people capable of actually setting out their thoughts and understanding them at that relevant time? So the reality is your capacity can be completely gone, except for the time when you make a will. It's your capacity at the time of making a will. But how do you prove that?
That's the thing.
This is the dangerous territory.
Yeah, because we struggle a little bit, certainly when we get people coming in to us to advise them when you're contesting, because it can be quite expensive. If someone is suffering from the early signs of dementia, do they have the early mental capacity? Now, we have to reform back into another act. Sadly, law works on two different acts, so you have to look at the Mental Capacity Act and the requirements under there. The second one is undue influence, which I suppose falls in the same bracket in some ways.
It's a similar category in that it's challenging the will, and undue influence, it's a bit of a Ron Seal thing. Have you been forced into making a will? Now, there's a difference between forced and influenced, and it's a bit of a balancing act. The courts will say, well, yeah, if you went of free mind because someone was quite hectoring, then that's not undue influence. That's just how life is. So it has to be something which puts someone sort of off course to such a degree that they wouldn't have taken that course otherwise.
Yep, and obviously then you got wills which haven't been completed correctly.
Yes, yep. Invalid execution. There's a number of things which you need in a will, such as it has to be witnessed by two people. Occasionally that doesn't work. Those people have to actually see you, the executor, complete that will. The executor has to sign it to put their mark, and the will must be in writing. All pretty common sense.
Yeah, and I suppose the contents of the will as well, which was quite interesting to me, was you're looking at specific people that you're wishing to give those And you can just sort of say, I want to give £1,000 to all my friends down the local pub.
Yeah, but certainty is a big one. We have people who do things like, I want to give my own inheritance from my dad to my daughters. And you say, well, how do you know how much that is unless you keep it in a certain bank account or in a certain way? There has to be a certainty as to what you're giving and a certainty as to who you're giving it to. And that gets missed out by people in their homemade wills.
So it's worth getting someone.
Yeah.
And I suppose, if you don't mind, we can go on to contested wills with,
of course, yeah.
In a sense of stepdaughters, stepchildren, which is quite interesting.
Yeah, stepdaughters, stepchildren, like you're saying, blended families. They tend to more come in, as we were talking about earlier, about dependency claims. So if people in your wider family and your blended family are missed out, who feel who should have something, and that can happen one of two ways. You've talked about dependency, but the other way is, for one I briefly mentioned, proprietary estoppel. Now, proprietary estoppel is almost like it's an enforceable promise that you'll give something to someone, and it would be unconscionable for you to go back on it by missing them out in your will or something.
Yes.
It's an area of law called equity, which is all about fairness. So you've got to meet some pretty tight criteria for it to apply. But again, it is something which is more prevalent, and again, due to the nature of the more mixed families people have.
Yes.
But the big one generally is the dependency claims, Dan.
Yes. Well, you mean the children or stepchildren?
Children, stepchildren,
yeah.
people who
traditionally, stepchildren, if you hadn't created a will, and you're going to intestines, then stepchildren don't have an automatic right. They have to prove it on the balance of that they were reasonably financially dependent on the living partner, the living person that's just passed. So they have to prove over a period of time, normally sort of around, if you've been living with that person for 20 years and you were financially. Now, what does that provide them if it's proven in the time scale that is? And we say 6 months. You may receive a lump sum, you may receive some of the estate. There is a certain criteria that you have to meet to show that what you're financially lost out on, effectively. For stepchildren, and we're seeing a lot more of these sort of contested wills coming into place now.
Yeah, very much so. People will divorce later in life now, and they'll have marry into new families. And in most situations, normally there tends to be divisions of a will more based upon their biological children, because their new stepchildren tend to be quite often in their 30s and 40s with no expectation. But equally, you find lots of people who are getting divorced with young families, marrying into new young families and raising the stepchildren as their own.
Yes.
And they don't really give thought to their wills, or they haven't really changed their wills from what it was with their original families. And you'll find people who always thought of their stepdad as their dad suddenly missing out. And it's often not about the money with them. It's about the emotional factor of this person who you cherished. If they're missing you out, was that reciprocated? And it's almost like they want a bit of a acknowledgement. And if the old children, the original children, completely blank you and say, no, it was all about us with our dad, our mum, or whoever, it's the emotional hardship which comes with it. So
yeah, it is an important point.
At least that's what strikes me, because quite often it really isn't sort of the estates are particularly large, or the money is particularly going to be life-changing. It's more a recognition.
Yeah, I found exactly the same, and it's quite unusual in a sense that what I found unusual was the fact that you're right in what you say, that they want this recognition, but we deal with a lot of emotional cases.
Yes.
Family and other emotional problems. But this sort of, for me, goes a little bit higher than that, because you're dealing with such two different elements of emotions with people, and we've got to be careful not to, or they're not advised ill correctly, miss deadlines, and it's done in the right process with the mindset of the emotions set behind what's gone on as well, and give them a realistic sort of timescale of what we need to achieve and how.
Yeah, very much so. We do have a number of clients who come to us with having put caveats in a will. That's a way to delay
Yes.
probate. And then without our knowledge, they've gone on to the next level, well, as in before they came to us, and put in something called a mention. And a mention is almost equivalent to a live court case. And as soon as you have a live court case, you can have costs, consequences. So when you tell these people, well, you haven't got a leg to stand on in this case, right, you put a mention in, the other side could claim their legal costs for you doing this. They tend to get very upset and angry. But when you explain how hard some of these claims can be to prove, it really doesn't hit home to them that they should take legal advice early. Which brings me on to the final point we alluded to, staples. No one knows this outside the legal world except our clients, because I drum it into them when we do a will. Never, ever remove a staple or interfere any way with your will, because the probate registry will check your will for interference. And if they see the old staple holes, they will assume that there's a page missing or a page added, and that your will is in some way being played with. And that could, well, not your will, obviously, but the person you're acting as the executor for. And that could invalidate the will. And you could find your probate does not go through. You may have to end up going to court and getting them to approve it, or having something called a statutory will, where the court says there is no valid will. Let's find out what the testator's intentions were. And I can guarantee they won't be quite the same as what was written in the will unless you pay a lot of money to rectify removing a staple. It is a nightmare.
So the point of the question, it can be an expensive staple.
It can be a very, very expensive staple. We're dealing with one at the moment, and I think we've identified the culprits. And it was just a head in hands moment where you think, oh my God, have to tell the client this, have to explain to them. And now it's a bit of an investigation to work out how to rectify this issue. And it's needless for a staple. So please never, ever remove that staple.
Or at least pop down to Marlborough and ask.
Yes.
That's the simplest thing.
Yeah, precisely.
Pop in any time.
Yeah, very much so.
Thank you very much.
Thank you.